What guidance can you give people on coming to arrangements for children?
Ideally, people will come to an agreement rather than going to court. Now, in some cases, that may be as a result of discussions that they have between themselves, but often mediation can help in the process.
When trying to reach an agreement, should people get legal advice?
It can be a good idea because in having discussions and trying to reach an agreement, it is often helpful to know what the outcome is likely to be if you go to court. Also, if you go to mediation, in some cases it can be useful to have your lawyer present at the mediation.
Should an agreement be documented?
Many people don't document agreements about the arrangements for their children and it all works out fine. But it can be a good idea to document your agreement. You can have a parenting plan or you can have orders made by a court. A parenting plan is not binding on a court.
What happens if people can't reach an agreement?
You will need to file an application with the court for parenting orders. Now, normally, when you file an application for parenting orders, you need to have what is called a Section 60I certificate, unless it's a case of urgency. Now, a Section 60I certificate is a certificate given to you by a family dispute resolution practitioner or a mediator. And it usually says that the parties have gone to mediation but couldn't reach an agreement. Or it could say that mediation wasn't appropriate in that particular case, perhaps because of violence, or perhaps it'll be given because one party refused to come to mediation.
What does the court take into account when making parenting orders?
The court regards the best interests of the child as the paramount consideration. There are two primary considerations in working out what is in the best interests of the child. The first one is the benefit of the child having a meaningful relationship with both parents. The second is the need to protect the child from physical harm, psychological harm, abuse, neglect, and violence. There is also a long list of secondary factors that the court takes into account. One of those is the views expressed by the child. Now, the weight that the court gives to the views expressed by the child will depend on the maturity and the level of understanding of the child.
Will the child be represented in court?
The court can appoint an independent children's lawyer or ICL. The ICL will represent the child's best interests. In doing so, the ICL will listen to the views expressed by the child, but ultimately will bring their own perspective to what is in the child's best interests.
What evidence does the court have before it when making a decision?
Each party will give evidence by affidavit, which is a sworn statement. They'll probably have witnesses who will also give evidence by sworn statements. At the trial, every person who's given evidence, put on an affidavit, can be asked questions by the lawyer for the other party.
Is there any independent evidence before the court?
Usually there will be a family report prepared by a family consultant from the court. They will also be asked questions by the lawyers about their report. In many cases, there will be subpoenaed material, which may be medical records, police records, school records.